Hello friends, welcome back to our channel Legal Nexus. In today's video, we are going to discuss a very important concept from law. The definition and nature of obligation. Obligation is a fundamental legal bond which connects a person who is bound to perform something which another who has the right to demand that performance. It forms the foundation of legal relationship, especially in the law of contracts and civil law. Understanding obligation help us know how duties are enforced and how rights are protected under legal system. So let's begin exploring the meaning, scope and essential features of obligation. The word originally derived from the Latin term obligare. The meaning of the term obligation duty to do or not to do something. Obligation is a civil law concept. An obligation can be created voluntarily such as one arising from a contract, quasi-contract or unilateral promise. Salmon defined obligation as the vinculum juris or bond of legal necessity which bind together two or more determined individuals. According to Aston, obligation is a kind of control exercised by determined persons over certain determinate persons for some specific act, or it may also be called a forbearance which has been valued in terms of money. Obligation under jurisprudence can be perceived differently in juristic sense, such as it can be defined as a duty in personam but not a duty in rem. In general, the former requires the obligation to pay a debt to enforce a contract or pay for damages in tort, while the latter deals with the obligation to refrain from interfering with others' identity, property, credibility. It is also defined as a duty clubbed with the correlative right of another person in the same transaction. This denotes the bond of legal necessity which the Roman law called vinculum juris. In the third sense, obligation is considered as a proprietary right in personam, which means a duty which corresponds to such a right, but the right which pertain to a person's status is not an obligation such as those created by marriage. Source of obligation in jurisprudence: contractual obligation, delictual obligation, quasi-contractual obligation, and innominate obligation. Contractual obligation according to section 2 clause H of the Indian Contract Act. Contracts are the agreements enforced by law. Contracts typically from an agreement between the parties who are legally bound by the terms of agreement. Such agreement must therefore be enforced by law and should thus be called contracts. Under a contract, the contracting parties have the obligation to meet the obligation they have established on each other. It creates right in personam between the parties but carries some exceptions like promise of marriage, which falls within the law of statutes. In a contract, in return for the promise made by other person, a party agrees to or to abstain from doing something, so we may assume that there are rights and duties that they have an obligation to fulfill on both sides of the contract. In situations where a party is unable to fulfill its duty or actively refrain from fulfilling its obligation, such a condition result in a breach of contract, and the party suffering from such a breach has the right to physically enforce the contract. Rights arising out of contract are right in personam, as the remedy available against is the party to the contract who makes breach of such contracts. Contracts create mutually of obligation as both promiser and promisee perform their duty and have right against each other in a contract. Intellectual obligation. There are the obligation arising out of tort. Tort is a breach of law that is deemed to be civil wrong. Civil in nature. Under tort, damages are unliquidated as opposed to contract where damages are inherently liquidated. tortious liability arising from the violation of duty against another individual. Dr. Winfield has defined liability in tort as tortious liability arising from the breach of duty primarily fixed by law. This duty is towards persons generally, and its breach is irrepressible by an action for unliquidated damages. It means delictual obligation are the duty of making pecuniary satisfaction for the wrong. For example, tort committed by the defendant. Such a duty is established by law, and individuals are allowed to comply with such a duty, and if they do not comply with their duty and cause harm to other individuals, then the person against whom tort is committed has the right to claim unliquidated damages from the one who didn't comply with the such duty. A wrongdoer therefore has the duty to pay unliquidated damages to the person against whom he commits wrong. Unliquidated damages are not predetermined. Quasi-contractual obligation. These are the obligations arising out of contract. These obligations are regarded by law as contractual through they are not so in fact. Primordial in Roman law, such obligations were called obligation quasi ex contractual, whereas in English law they are called quasi contractual. The contracts which are created out of the interference of court but not by the formal agreement and the parties concerned are termed as quasi contract. These are fictional contracts. Quasi-contractual obligations are very precisely defined with examples under Chapter 5 of the Indian Contract Act 1872. The obligation of a parent towards their child is a well-defined illustration of quasi-contract. The relationship created trust is yet another example. Innominate obligation. Salmon defined innominate obligation as a residuary class of obligation. Innominate obligation are those which are not purely contractual, delictual, or quasi-contractual. This means they do not have a particular designation or term. For instance, trustees' obligation to beneficiaries. A trustee has a fiduciary obligation with respect to the beneficiary. A trustee is directly responsible for infringement of the obligation he has on the beneficiary's property. There are two kinds of obligation, sole obligation and solitary obligation. Sole obligation. Sole obligation is one which there is one creditor and one debtor. For example, A promises to B to pay rupees 100. In this example, there is only one creditor and one debtor. Solitary obligation. In case of solitary obligation, there are two or more debtors on the same thing to same creditor. There are three kinds of solitary obligation. See kinds of solitary obligation. Meaning of solitary obligation. Most cases the obligation is between two people, but solitary obligation refers to obligation that involve more than two people. On one hand, there may be two or more parties, and on the other hand, there may be two or more parties. When two or more people on their obligation to the same person, this is an example of solitary obligation. In this case, the person with the right can appoint any of the several people entrusted with the duty to carry out the task. In other words, if you have a creditor on one hand and several debtor on other hand, all of whom are on the same debt to same creditor, the creditor can ask the any of the debtor to pay debt. Kinds of solitary obligation. In English law, solitary obligation are three distinct kinds, which are several obligation, joint obligation, and joint and several obligation. Several solitary obligations. Solitary obligations are several when although the thing on in the same image. There are many distinct obligations and causes of action as there are debtors. Joint solitary obligation. Solitary obligation are joined when though there are two or more debtors, there is only one debtor on other cause of action, as well as only one thing owned. The creditor must sue all of them, and release of one of operates as a release of others. For example, when a film contracts a debt, all the partners are jointly liable. In English law, liability of joint debtor is joint, while in India it is joint and several. Joint and several solitary obligations. Certain solitary obligations are both joint and several. These obligations stand midway between the above two. In this, the creditor can sue one or some, all of them, and release of one will not operate as a result release of all other fees. So, to conclude, obligation is not just a moral duty but a legal bond that creates enforceable rights and duties between parties. It highlights the relationship between the person who is bound to act and the person entitled to demand that act. By understanding that definitions and nature of obligation, we gain clarity on how law regulates human conduct and ensure justice in society. Stay tuned for more such legal concepts in our upcoming videos. If you found this video helpful, please don't forget to like, share, and subscribe.